You are listening to the Aging Starts Now podcast, where it's all about responding with confidence to the legal, financial, and personal challenges created by a disability, unexpected illness, or aging in general. Join us weekly as elder law attorneys Barbara McGinnis and Chris Johnson, along with other members of the Johnson McGinnis Elder Care Law and Estate Planning team, talk about the tools, techniques, strategies, and services that will make the elder care journey easier for everyone involved. Get ready, because aging starts now.
Do you have a will? What happens if you pass away before creating this document? I'm Outreach Coordinator Dana Hentschel, and on today's episode of Aging Starts Now, we are talking about dying without a will. Joining me for today's conversation is attorney Josh Hunter. Welcome, Josh.
Hi, Dana. Thanks for having me.
So, Josh, what happens if you die without a will?
Well, in short, it kind of depends on what you own and how it was held and what the plans for the future look like, I guess, for those that are going to survive you. But in short, what most people are going to be worried about is the messy business of intestate succession. That means if you have assets that would require probate, right, because they don't have a label on them, you don't have a will to guide the probate court in administering your estate. So instead, they're going to have to rely on the statutory default known as intestate succession, where we kind of joke with people in our firm, if you don't have a will, the state has one for you. And it's basically a list of your heirs until they find a survivor who can take the portion that's owed to them.
So I've spoken with some people and they say, well, I don't really need a will because my house and, my husband and I own our house together. So if I die, it automatically goes to him and vice versa. And I've got beneficiary designations on everything.
Okay, well, the good news is beneficiary designations avoid probate, right? So the way I try to explain probate to families is probate is only for assets that don't have a label on them when you pass away. And what I mean by that is beneficiary designations or payable on death, well, that's designated where it's going to go after you're gone. Joint ownership with right of survivorship, when we're talking about real estate, well, that has a label on it. We know it's going to go to the survivor. Though it doesn't necessarily help them with their planning, right? They still need a will after that expires. But those assets that move without probate aren't necessarily affected on whether or not you have a will. But my caution to that is that people have and gain assets all the time, right? So you have what you have, but it's probably not going to be what you have forever. Assets come into your life, things are sold, new things are acquired, things are inherited, things are given away, whatever that may be. And the short answer on do you need a will or not, if everything has a beneficiary designation, is, well, maybe not, but it is a gamble, and it is a potential hole in your estate plan that can cause undue burden and headache for your survivors.
Right. And, I've heard you tell families, do you and your husband travel places together? Do you go places together? You're in the car together. So it's possible that a tragedy could strike both of you at the same time. And then what happens?
That's exactly right. You're leaving this huge gap on assuming everything is going to go exactly the way you imagine it. And for any of us that have lived any amount of time, we realize that that is often not the case, right? I remember hearing a phrase here at our firm once, God laughs at our plans, in that, we can have a great idea of how it all works out and life throws you a curveball. You're exactly right. So having stopgaps and having a plan for just in case is prudent planning.
All right. So I've also heard y'all say that a will is a ticket to probate court. Like a will has to be probated. But even if you don't have a will, you go to probate court, correct?
That's exactly right. So just because you have a will, that is not going to allow you to avoid probate. And I think that's a common misconception that I know the focus today is what happens if you don't have a will, but let's clarify what happens if you do. It all goes back to whether or not those assets have a label, right? So if they don't have a label, right, things typically like real estate, you can't put payable on death on your home. But if it's not held jointly or it's held as tenants in common or you're a solo owner, that's often something that lands families in probate. And if you have a will, that's just going to act as guidance for the probate court. A will does nothing else unless it goes to probate, right? It's just a sheet of paper unless it goes through the probate process. If you don't have a will, that doesn't change the big question of who gets your stuff when you're gone. If it doesn't have a label, it needs to go through probate. And if you don't have a will, well, you're just defaulting into that statutory default of intestate succession, and probably not the way you want it to go.
So, what is the plan? What does the state have in mind for you if you die without a will?
Well, I kind of think of it as a Christmas tree, if you will, as a good visual to see how it branches out until it finds an heir that can inherit. So starting most simply, if you have a spouse, your spouse is situated to receive some of what you have to the extent of either at least a third or a child's share, unless they can claim more based on specific circumstances. But it's rare that you're going to have a time where a spouse gets anything less than a third. That's typical. If you have children, it's going to, what would be left between your spouse and your children will have equal shares divided amongst them, right, depending on how many you have. So, for example, if you have a spouse and one child, it would go half and half, right, because your spouse gets that child share, which is greater than a third, and your child would get that remaining half. But if you have 4 children, well, that means your spouse would likely get a third if they can't get the elective share, which is up to 40%. Let's just say they get a third, and then the remaining would be split amongst your children. But that can get messy, as you see quickly. What if you don't have a spouse and you have no children, right? You're somebody that we would consider a solo ager. Well, it's going to go through your bloodline until essentially it finds somebody it can take. So it tries to go down the Christmas tree first, right? Do you have, any descendants? If you don't, then it goes back up and branches out again. That's why I think of it as a Christmas tree. It'd go up to your parents. If none of your parents are surviving, do you have siblings? Did your siblings have kids? Well, if not, now we're going to go to grandparents, and then so on and so forth until it finds somebody who can inherit. But very rarely is that going to line up with exactly how you want your estate planning to go.
Right. I mean, I immediately think of, you've got the dad and the 2 children. Maybe one of the kids is dad's friend and confidant and taking care of dad and all of that. And then you've got the mooch brother who's been estranged forever. And all of a sudden, dad passes.
And there they are splitting it 50-50 when they didn't do 50-50 of the work, right?
Right.
And that's definitely going to involve some hurt feelings and squabblings and whatever else. But don't forget, who gets what is only a part of the probate process, right? Who actually stands to inherit is only a portion of it. Don't forget about the creditors piece, where, if you owe things or if someone has reason to cause a stink, if you will, or step up and cause problems, probate's the right time to do it. And we often hear stories of long forgotten people or creditors or whatever it may be appearing right during the probate process with their hand out, looking for their piece of the pie. And that's not the way you probably want things to go. And particularly if it becomes contested, it can be very expensive and difficult.
Right. So if there is no one else, you truly are a solo ager and pass without any paperwork, who opens up probate? Does the state?
Typically, no. A good example of what may happen if there are no heirs at all would be who's trying to reach property, right? And oftentimes that could be creditors, trying to pursue the estate, or people who have some reason to try to get a payout from the estate, right? But that's worth noting that there's almost always an heir out there somewhere. Because as you work up and down that Christmas tree model we were just talking about, it'll eventually find somebody. There's some cousin out there or something. I guess there is a possibility that there's absolutely no one. It goes through your entire family and finds no survivor who can take it, at which point the state would technically inherit, but that's exceedingly rare.
Okay. So what if you hear this episode and like, well, I don't have much, but I'm going to do a handwritten will.
Oh, handwritten wills. I love them.
That'll take care of it.
So handwritten wills are a real thing. A holographic will can be effective if it's executed properly. And that's worth noting, that it needs to be handwritten, it needs to be signed, it, preferably needs to be dated, witnessed, all those sorts of things. But it's generally considered less favorable due to the fact that, can it be replicated? Was it edited? Could it get destroyed because it's just on paper? How is it being kept? How do we know if there were others that were executed too? And if you're just interested in finding something fun to read, looking at the estate of Aretha Franklin and what exactly a handwritten will can do for you is a potentially a fun read for our listeners out there, where multiple handwritten wills stuffed in couches and here and there, and you're dealing with obviously a sizable estate, became an unnecessarily burdensome process and a messy affair, when simply, working with an attorney to get things organized and structured to reduce some of that would have paid serious dividends for that family, right?
Right. Exactly.
That lines up with another question we often get is, what about if I've just verbally told everybody what I want? Does that count? And we get to use a fun phrase here. A non-cupative will is a real thing. A verbal will is a real deal, but rarely conversations, meet the requirements to be considered an uncupative will, right? Your usual conversations and letting your family know who gets what are rarely going to fulfill those requirements to actually satisfy everything. So those people pass away with intestate succession and dealing with statutory defaults, even though they tried to make their wishes known. Generally speaking, those conversations won't matter. So I definitely wanted to throw that in.
And I guess maybe after you pass, people change their minds. They didn't like your verbal will.
Sure. Of course that could happen, and it's a sad and unfortunate reality that we deal with, where people get angry and greedy and spiteful and digging up old issues and all these sorts of things when money and assets come into play. It's sad. You would like to believe that your family would never do that, but as professionals in the industry, we see it entirely too often.
Right. So, Josh, are there any other points or ambiguities you would like to clear up on this topic, or anything that you see often enough to dispel?
Well, two things. First, I would say understand that a will does not avoid probate, but it's definitely better than not having one. There are benefits to it. Basically, everyone needs a will or a will substitute, depending on if you're trying to avoid probate. But while it may not be your most important document, it is very important.
Right. Very important, whether you are a solo ager, but especially if you have a family that you love, or a family that you don't like, because you don't want them to get things if you don't want them to.
You're not kidding. That knife cuts both ways.
So, well, that is all the time that we have for today. If you know someone who has put off getting their affairs in order, send them this episode. Johnson McGinnis Elder Care Law and Estate Planning is a life care planning law firm helping families navigate the legal, financial, and care questions that often arise as we age. Please join us next week for another episode of Aging Starts Now.
Thank you for listening to the Aging Starts Now podcast. For more information about today's show, visit tn-elderlaw.com, click on the Free Resources tab, and then click on Aging Starts Now. You'll find the show notes there. And while you're at it, why not check out all the free resources available at tn-elderlaw.com. Document downloads, the Johnson McGinnis blog, educational videos, informative articles, helpful links, a TV show, and more. It's all there, free for the taking. If you enjoy listening to the Aging Starts Now podcast, please subscribe, rate the show, or leave us a review. It's easy to do on whatever app you use to listen. We would love your feedback on the show. Aging Starts Now. We'll be back next week with more candid discussions about the challenges created by aging, disability, and unexpected illness.